He is innocent. Help free Dr. Malachi Z Kobina York Ocran. Narrated by Hektet Senentet Hoteptet. Fact 1. Dr. Malachi Z Kobina York Ocran's legal nationality and diplomatic status. Dr. Malachi Z Kobina York Ocran is a Liberian diplomat and national citizen of Liberia under the legal document of Republic of Liberia in Monserrado County. In the First Judicial Court, Criminal Assize B, sitting in its February term AD 2005, signed by Clerk of Court Samuel A. Pasawi, in March 23, 2005 AD, and legal citizenship document issued December 15, 1999, notarized by Notary Mary Man Mihawi and signed by Clerk of Court aforesaid Samuel A. Pasawi, and is being held in U.S. custody under the misnomer Dwight D. York, wrongfully incarcerated and needs to be repatriated to Liberia. These documents are recorded and recognized by the country of Liberia and are published online at www.liberiafreedryork.com and www.nawabianfacts.com. Liberia is requesting for the repatriation of Dr. Malachi Z. Kobina York, whose diplomats were refused the ability to visit Dr. Malachi Z. Kobina York. Please help by sharing the facts and conspiracies in this video to expose the truth and help free Dr. Malachi Z. Kobina York, affectionately called Ba'ah Ba'ah Yanuwn. Dr. Malachi Z. Kobina York is erroneously being held in Florence Ad Max U.S. Penitentiary under the misnomer of Dwight D. York, prison number 17911-054, as he was vested with protection interests of these nations as an ECOWAS citizen and was made very clear in the 2016 proceedings in ECOWAS Community Court of Justice, where Dr. Malachi Z. Kobina York was determined to be a consulate general and diplomatic personnel. He has been illegally held in U.S. federal prison for over 16 years and is now 73 years old and a very ill man, suffering from a life-threatening illness called hereditary angioedema, where he has had several life-threatening attacks and close calls on his life. Upon Dr. York's arrest, he informed the arresting federal agents that he was a diplomat of Liberia, which I personally witnessed. Diplomatic immunity for consulate general. According to the federal rules of criminal proceedings, Rule 5, Initial Appearance, Section 4D1F, Procedure in Felony Case. 1. Advice. If the defendant is charged with a felony, the judge must inform the defendant of the following: that a defendant who is not a United States citizen may request that an attorney for the government of a federal law enforcement official notify a consular officer from the defendant's country of nationality that the defendant has been arrested, but that even without the defendant's request, a treaty or other international agreement may require consular notification. Pursuant to the Diplomatic Immunity Act 22 U.S. Code Section 254A and the Vienna Convention Guidelines for diplomatic, specifically consulate generals, Dr. York had the right at the time of his arrest and pre-trial hearing for his arresting officer and attorney and court to notify his government officials of his apprehension. However, that was not exercised. In recent news, a U.S. man was taken into custody by Russia for acts of espionage. He was ex-military. He was not a diplomat. However, the U.S. intervened and said they wanted to hear the charges brought against him, and if the charges were not suitable for espionage, they wanted him immediately released and extradited back to the United States. Why then wasn't this same right afforded for Dr. York, a consulate general for Liberia, who had legal documents to prove it, that according to the Vienna Convention guidelines, he did not have to produce, but was able to. And if the court was found not to have jurisdiction over a diplomat, he should be immediately released from custody. So did the court have jurisdiction? No, they did not. Why? Because according to testimony of the lead investigating federal agent Jelaine Ward, in charge of the investigation brought on Dr. Malachi Z York under the misnomer Dwight D. York, she had no witness to testify that Dr. York was responsible for any of the alleged victims' travel from New York to Georgia. Therefore, the interstate charges were not valid. They were going solely on testimony without any evidence whatsoever to back them up. Testimony that was gathered by the state officer who went outside the scope of his duty to act as his own hired private investigator, which in itself shows a biasness and personal vendetta against Dr. York. Fact 2. Plea bargain. Plea bargains are often the first thing the attorneys, courts, and prosecutors encourage because it saves court fees and it saves both the judge and prosecutor time. In the plea agreement, defendant waives his 4th, 5th, and 6th Amendment rights. Some plea agreements are enforced to force the defendant to testify in court against another defendant. This was the case with Dr. York's wife and the other 2 co-defendants who rendered an Alford plea agreement. According to Cornell Law School Legal Information Institute website overview, many successful criminal prosecutions in the United States end not with jury trials, but with plea bargains. Plea bargains are agreements between defendants and prosecutors in which defendants agree to plead guilty to some or all of the charges against them in exchange for concessions from the prosecutors. These agreements allow prosecutors to focus their time and resources on other cases and reduce the number of trials that judges need to oversee. In plea bargains, prosecutors usually agree to reduce a defendant's punishment. They often accomplish this by reducing the number of charges of the severity of the charges against defendants. They might also agree to recommend that the defendant receives reduced sentences. Some plea bargains require defendants to do more than simply plead guilty. For example, prosecutors often offer favorable plea bargains to defendants who agree to testify for the state in cases against other defendants. According to the Department of Justice's Bureau of Justice Assistance, the overwhelming majority, 90 to 95% of cases, result in plea bargaining.